At this time, I would like to call the meeting to order. Good evening. Today is Thursday, April 25th, 2024, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. I'm the chair, Zakia Wright. I'd like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Quiche people. Commissioner Agassi, would you lead us in the Pledge of Allegiance? Madam Secretary, may we have the roll call, please?
Yes. Commissioner Bass?
Present.
Commissioner Kerpes?
Present.
Commissioner Rory?
Present.
Commissioner Topshin?
Here.
Vice Chair Moore?
Here.
And Chair Wright.
Present. We have a quorum. If everyone's had a chance to review tonight's agenda, I'd entertain a motion.
Motion to approve.
And is there a second?
Second.
We have a motion to approve and a second. Madam Secretary, roll call, please.
Yes. Commissioner Bass?
Aye.
Commissioner Kerpes?
Aye.
Commissioner Rory?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Moore?
Aye.
And Chair Wright.
Aye. We also have the minutes from our last meeting, which was over a month ago, March 14th, 2024. Is there a motion to approve?
I have a correction before we do that.
Okay, proceed.
On the second page, when we voted, the vote was 3-1, and I asked Dan to come up with some language to indicate that I was the no vote.
Yes, and it'll be amended with noting the no vote of Commissioner Bass.
So with that change, I would move to approve.
Okay. Are there any additional
Second.
changes? Seeing none, I believe you were making a second, Commissioner Rory.
Thank you. Yes.
We have a motion. We have a second. Madam Roll Call.
Commissioner,
Madam Secretary, roll call, please.
Commissioner Bass?
Aye.
Commissioner Kerpes?
I'll abstain.
Commissioner Rory?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Moore?
Abstain.
And Chair Wright.
Aye. The motion passes. Do we have any speakers for the public?
No public speakers at this moment.
Alrighty, so moving on to the next item on the agenda. Item number 7 is the manager report. And we will hear from our acting rent stabilization manager, Gloria Vilas. The floor is yours. Thank you.
Good evening. Can you hear me? Okay. Good evening, Chair Wright and Commissioners. Tonight we'll be hearing 2 appeals, Appeal D4710 CD3 and D4817. For the next meeting on April 9th, we had scheduled an appeal as well, but it looks like it won't be heard. So we're still looking to see if maybe that meeting would be canceled, only because there may be a presentation from staff coming, but just giving you a heads up that we're not sure if that's going to be able to happen. On the May 23rd, we will probably double up on what wasn't heard on the 9th, will be probably heard on the 23rd. So, and then for June 13th, we have a D4837, and June 27th is going to be a full meeting, since we're going to have 1 appeal and the announcement of the AGA, as well as the changes on the relocation fees and temporary relocation expense. I do want to let you know that tonight there's also a staff item with regards to WeHo Pride 2024 and the participation to be involved in the float for the parade. And that's it.
I have a question regarding the next meeting that may or may not be canceled. I think we used to get like updates from Eugene Maskey or someone with CES on what was going on with like renters, et cetera. Is there any way to plug in a presentation on that date, or maybe one of the maybe less heavier agendas that we have coming up?
I'll look to see if it's something that he can do with such short notice. I'm not sure if we can get him here for the 9th meeting, but it is definitely something that will be coming in this year as far as reporting.
Okay, awesome, thank you. Are there any other questions or comments for staff? All right, thank you. Moving on to agenda item number 8, tonight's appeal. We have 2 on our agenda tonight. Excuse me. Starting with D4710 CD3, it's a appeal for a compliance determination, and D4817. From what I understand, all parties, or almost all parties, are in the chamber this evening. And so first, we will have staff go over the staff's report for the first appeal, and then we will have the appellant come up. I believe in both cases, the appellant is the tenant. The tenant, you will have 5 minutes. You can use your time as you see fit. You can use 2.5 to present your case. You can use 2.5 for your rebuttal. You can take it as you will. Just let me know when you come to the podium how you want to divide your time. Then the respondent, which in both cases tonight is the tenant, you'll have 5 minutes. That's not divisible, so you'll be able to use that 5 minutes to rebut or to make your case. When it's your time to speak, please state your name and city of residence for the record. The appellant will then tell me how they want to divide their time, and then you can proceed with your comments without any additional prompt from me. We do ask that you stay on topic. We can only consider or make a decision on items that are on appeal, and so anything outside of that, they may be helpful for context. We can't make any decisions on those, so please keep your comments narrowed. And legal counsel, can we have staff report for our first appeal this evening?
Thank you. Good evening, Chair, Vice Chair, members of the Commission. My name is John Natalizio. I'm the legal counsel for the Rent Stabilization Commission for the City of West Hollywood. And so this appeal hearing is resulting from a hearing examiner's compliance determination, which is restoring a $27 rent decrease relating to peeling paint in the tenant's unit. The landlord filed for a request for a compliance determination, stating that the landlord had painted all of the peeling paint in the unit as required in the order. The landlord submitted an invoice and photographs in support of this request. Tenant did not submit any objection to the request. The hearing examiner reviewed the request and the evidence submitted. The hearing examiner noted that tenant made no objection, and accordingly, there was no hearing set on the compliance determination, and the hearing examiner issued a ruling which found that the landlord had complied with the decision's order and restored the $27 in rent. Tenant filed an appeal which claims that the decision is clearly an error and not reasonably supported by the findings or evidence in the record. And specifically, tenant is arguing that the paint continues to peel. Excuse me. Staff believes that the hearing examiner did not err, that there is substantial evidence to reasonably support the hearing examiner's decision. So the compliance determination, landlord submitted the request with the invoices the invoice and photographs supporting the claim that the work had been substantially performed. This evidence creates a presumption that the work was performed. Tenant failed to submit any sort of objection to the request, nor any sort of documentation refuting the landlord's request. And therefore, staff finds that the hearing examiner clearly evaluated and weighed the evidence submitted by the landlord and determined that the landlord was able to meet the burden of proof. Therefore, staff is recommending adoption of Resolution RSC number 24-646. You as the Commission have the power to reverse, affirm, modify, or remand the appeal decision of the hearing examiner. The Commission reviews the hearing examiner's decision under the substantial evidence standard, which requires that the Commission make sure there's substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there's also evidence that could support a different outcome. The Commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. And as it relates to questions of law, the Commission applies an independent standard to review those conclusions of law. Thank you.
Are there any questions for staff?
I have a couple questions about the process of how the determination is processed. So the landlord, as you mentioned, files a compliance determination and submits whatever evidence they want to submit. And the city sends a letter to the tenant letting them know that that's under decision?
Correct. So the landlord files a request for a compliance determination. A notice will then be sent from the city to the tenant informing them that the landlord is seeking a compliance determination request. It'll notify the tenant that you have the right to object and present evidence in support or against this request for compliance determination. It'll tell the date you have to, submit the objections and evidence by, and then once the city, if the tenant does the objection and submits evidence, is then provided to the hearing examiner, and then it is within the hearing examiner's discretion if they want to set a hearing for further discussion.
So, and that's just through the U.S. Postal Service, it's one letter that's sent from the city?
Correct.
And then if once the hearing examiner makes a compliance decision, that decision is then sent to the tenant as well?
It should be, right, it's mailed to all the parties, correct?
And is that just through U.S. mail as well?
Yes.
And why is it that so when they receive the first letter, they have the opportunity to present evidence, but when they receive this determination letter, it would only be to appeal. They would not be able to produce any evidence not already in the record, right?
Right, because their opportunity to present the evidence is at the time of the objection, when they get the notice that the landlord is seeking a request for compliance. So once the hearing examiner has made a decision, it's the same thing as a normal case where if it's not compliance determination, when the hearing examiner issues a decision, the parties don't get to resubmit additional evidence to that decision.
Yeah, I guess I'm just concerned. So it sounds like if they missed their one opportunity, they missed that one letter, they wouldn't necessarily know, because the landlord could take 1 month or never file for a determination. So it's not like we have they should be on the lookout for for anything. I'm just wondering,
Right. Well,
It's almost like
there's
a
no
false
obligation
sense
for a
of-
landlord to.
ensure that the tenant receives the notice.
Well, sure, but I mean, to the extent that there's no obligation for the landlord, for example, to restore the housing service. I mean, that's what the point of the rent decrease is for. Unless certain provisions, they would have to, but in general, right, the compensation would be this rent decrease. So, to the extent of the tenant won't be on the lookout for it. I mean, that is the point of the notice, though, is letting them know that the landlord has filed something in which or filed a request in which they believe they've complied with the order. But to the extent, is there other noticing mechanisms? No, it's just that city notice.
And would we, I'm not suggesting this, but do we even have the option, would the city have the option to, in cases where the tenant did not respond on that first notice, did they forfeit their appeal right? Because it seems like a false, they can appeal, but they really can't appeal because there's no evidence for them to appeal upon.
Yeah, I mean, they don't forfeit their appeal right, but it's the same standard as every other case, which is they would have to present sufficient facts and evidence for why, with due diligence, they could not have presented the evidence at the time of the objection, right? And so that same standard would apply, and simply not doing it wouldn't qualify for that, but it's the same standard here. And additionally, the argument could be made, for example, if they looked at the evidence submitted by the landlord and they said, I don't think that that's sufficient, they could argue that the hearing examiner did err or that there isn't evidence in the record that really supports that decision. So they could argue that what is in the record isn't sufficient. So I don't think that this is not a farce. I think that they still have, this process is still affording them an opportunity to address, I think, wrongs that they perceive in the process.
Thank you.
Is it accurate to say that were the tenant to have appealed the landlord saying that they had complied, that the subject matter would essentially be, the tenant submitting evidence that rebuts that? And then on appeal, it's not that it's not necessarily about the evidence or the subject matter. It's really whether the decision by the hearing officer conforms with the evidence of record.
Right. So for purposes of the objection, that is just giving more evidence for the hearing examiner to evaluate and making their decision. That's the point of this objection period, is to give the tenant an opportunity to submit facts, evidence, or argument to rebut the landlord. The hearing examiner is then to take all of that information and documentation, analyze it, and determine whether or not they believe there has been substantial compliance with the order. And so then on appeal, it's the same standard as a normal case, which is the commission looks at it as to, from a factual standpoint, if the hearing examiner's compliance determination is supported by substantial evidence, or if there's a legal question, whether they correctly interpreted, a provision of the code or law correctly. But the original objection period for providing the evidence is purely for the hearing examiner to have just additional matters for their own evaluation in the process.
Thank you. Are there any additional questions?
Just a quick one, maybe Gloria, you can help. Is there any time frame? How many days the tenants have to 10 days. Submit any evidence to object the compliance determination?
I believe it is 10 days for them to respond.
Okay. And as a follow-up, then probably to the legal counsel, the email that is dated January 26, 2024, I assume with the attached photographic evidence, this was submitted to those images that show appealing paint. These images were meant for the commissions, for the meetings tonight, or it was to...
So that was a part of the appeal packet that was submitted by the tenant. Okay. So to the extent that those photos are in the packet, the commission would first have to make a determination that this is new evidence they can consider. But yeah, these were photos submitted by the tenant with the appeal. So if the commission finds that these new pictures cannot be submitted, then these should not be considered by the commission.
Thank you. And that's the reason why I asked. Thank you.
Commissioner Rory? Okay, sounds good. Any additional questions from the commission? Okay. Alrighty, with that, I will go ahead and call the first appeal this evening, D4710CD3. The appellant, Lynn LeMay, please step forward.
My name is John Ainsworth. I'm going to be speaking on behalf of Ms. LeMay.
In the microphone, please.
Sure. My name is John Ainsworth. I'm a close friend, and also I have the designated power of attorney for Ms. LeMay. I'm also a tenant at the 1279 North Harper Avenue, which is the building that is in discussion. In looking over everything,
before you begin, how do you want to divide
sure.
your time? You have 5 minutes.
Probably just 2.5 and 2.5.
Okay.
Yeah.
All right. Thank you. You can begin.
Thank you. So I wanted to say that in going over all the paperwork from the whole hearing and everything, I was unaware that there was a time frame that Ms. LeMay did not meet the schedule for the appeal. So that's news to me as of right now. But with regards to the photos that were submitted by the landlord, those photos, when we were made aware of them and we did take a look at them, they do not show accurately what is going on in her apartment. For example, one of the photos actually looks as though the cabinets in her kitchen are white, when in reality they're like lime green. So I don't know that those things could actually show the paint. I do have photos and I have 3 copies for everybody that are from last night. That if anyone wanted to take a look at those, I'm more than happy to provide them. I'm not sure if they're as submissible. So I don't know. That's I guess as far as I can state right now. Is there anything more?
Well, those photographs are exactly what I look at every day. The walls are true. It's not the walls, it's the woodwork in my apartment. It's the doors and the woodwork around the doors. It's not the ceiling, it's not the walls.
I'm sorry, I'm having a hard time hearing with you. There's a portable one there too.
Yeah, if she wants to come to the microphone, if you want to take it to her.
Sure.
And then if you could repeat your comments into the microphone so we can all hear you.
Sorry to interrupt, I just couldn't hear you.
What I want, can you hear me? Yes, thank you. My name is Lynn LeMay. I've lived in this apartment for 33 years. It has never been painted in those 33 years of living there. When I requested it to be painted, it was at a time when I also, after I made the request, I had to go to the hospital. I was gone for almost 11 months because of various problems. Anyway, when I came home, shortly after I came home, my landlord said, we want to come in right away and paint your apartment. I packed up everything in my apartment, every tchotchke, every picture, every pots and pans, everything. So then the painters came in. The man who did the paint is a lovely man named Ed. He's been a painter for over 45 years. The first thing he said to me when he walked in the door was, we have a problem. There's a letter in that packet that you have access to, and the letter clearly states that Ed said to me, you've lived here 33 years, and back in those days, they painted everything with oil-based paint on the wood. Now that's against the law. Scott Properties wants me just to apply water-based paint on top of the oil-based paint. I will warn you in advance that within matters of days or months, that paint will peel off after I put it on, because the job that needs to be done needs to have the doors and the woodwork stripped all the way down to the wood, and then technically you'd have to go out of your apartment for 2 days while I apply a product
Ms.
that's...
LeMay, you are at 2 minutes and 30
Yeah, I was
seconds.
gonna say,
Would you like to proceed?
I don't
we
want
should
to
stop,
but I
so-
just want you to see that when everything happened exactly as the painter told me. He painted, and within a matter of less than 2 weeks after he finished painting, the paint started peeling off. And then I took pictures. I went down to the Written Stabilization office. I filed an appeal. I took pictures with me. I gave them to Eric Fountain, the person at the Written Stabilization office that handles these appeals, and I left pictures with him. And so that started this process, because I said, if they're not going to do the job right, then I will continue living with the paint peeling from now till...
Ms. LeMay, there's 2 minutes and 15 seconds left. Would you like to continue your statement or save time for rebuttal?
I think we'll wait for the rebuttal.
Okay.
Are there currently any questions for the tenant? Commissioner Kirkes?
Yes, I have a question for you, sir. Or either one of you, whichever would like
Sure.
to answer. But so the issue here this evening is that the compliance decision was a determination of a compliance was going to be issued, and they sent a letter saying that this was going to be decided. Do you have any objection? And the city didn't receive any response. And then I believe your appeal is timely. There's no question about the timeliness of the appeal, but the appeal is providing evidence that we can't consider because it wasn't part of the hearing examiner's determination. The questions that we had for council earlier were, based upon those questions, can you tell us why those letters, or why you couldn't have produced those photos and that evidence prior to the determination actually being made?
I'm not aware of the timeline of all of this, because it's, in going over this, I'm not sure exactly what the dates are. That might be helpful if I had a clear understanding of when things were not submitted by, because I believe that we've been doing this since 2020, so it's...
I guess my real question is, did you receive the letter? Did Ms. LeMay receive the letter? And if so, why the evidence wasn't provided?
Wait, yeah, go ahead.
I said, I've received numerous letters, but I've never had any letter telling me, other than the letter that said, from now on, you cannot continue taking the $27 off your rent every month because we painted your apartment. And that was their, and I said, well, you painted it, but the job is not sufficient, and I'm still having problems. I did take the pictures I took at that time, which was over a month and a half ago. I took them to City Hall. I left them with Eric Fountain, and I filled out an appeal.
I understand. I don't mean to cut you off, but my question just was about the letter. But thank you. I think you answered it as best you could. I have no further questions.
And the letter that that he's referring to, it would have been at least dated November 29th, 2023. And it would have been from the city.
Let me set this down so I can look through the paperwork. Sorry.
It's like 3 in this case. I do have a few questions for the tenant, though. If you can provide her the book that's on the the dais. All right, and if you turn to page 22, the Bates number, there are a few photos there, and I just wanted to ask you sort of questions of when these photos were taken.
Open the 22, you said, correct?
Yes.
Okay.
So pages 22, 23, 24, 25, all the way through 30, they all have pictures, and I'm just curious what date, if you recall, when these photos were taken.
I can tell you exactly because I have them in my phone.
Yes. I took those pictures literally within less than 3 weeks after the paint work had been originally done. Because the paint peeled off of the woodwork, it peeled off my doors, it peeled off the green paint in my kitchen, it peeled off the woodwork, not only the screws that hold the doors up over the metal, the paint peeled off the metal. And so I started complaining to the city, and I was told you have to file a review. So I went in, I filled out the paperwork, and I took the pictures with me, and I left the pictures with Eric Fountain. And I said, here are my pictures. I filled out the review request, and he said the $25 fee was waived because of my age, whatever. So I did that. And then then there was an appeal, then the appeal process took place. And then the city ended up, Scott Properties ended up saying that as far as they were concerned, the paint got done. The painting got done. Yes, it got done, but how can you say a job is finished
Okay,
when
that's
the whole thing?
Thank you. Yeah, I just had that question. Okay.
January 24th.
Okay, January 24th. Thank you. And you started to answer my second question. What areas are peeling? Is it the doors and the doorways, or is it more than that?
The inside of my front door, the door to my closet, the woodwork around the door to my closet, some of my baseboards, some of the other door frames that go around the door to my bathroom, my bedroom, a closet, into my kitchen, some of the bottom baseboards, anything that is a wood surface in my apartment. The wood is what has the oil-based paint on it and what will not accept the water-based paint that has been put on it. In order to fix the problem, it can be fixable, but only if the painter is allowed and Scott Properties is willing to pay a large sum of money for him to peel all the paint off down to the wood.
Okay,
And that means
thank you. Thank you. I don't want you to get into testifying because that'll give you more time than you're permitted. I had one more question on page 215, if you can turn there for me.
215.
And it's page 215 to 222. It's just a sort of a collage of photos. It looks like this was probably submitted with your original complaint.
Oh, yes.
Can you identify which pictures are of sort of the areas that are peeling? Like, which are the interior areas? Because it's sort of a mix of indoor-outdoor pictures.
Right. I believe actually these were not the photos from the initial. These were photos taken after the work was done, because this is showing one of the work that had not been completed when they first gave the submitted for compliance determination stating that they had done the work. This was to refute that evidence as well. That's and I know that because, for example, the light fixture was broken by the painters at the time when it was installed, and so that was to show that, and the dirty, the paint peeling as well on page 215.
Some of the pictures of the pages you just are referring to is because the day after the painter was finished.
I just need to know which ones are the interior. Yes, please.
Thank you.
But you can say that part once you're back on in your last remaining minutes. Yeah, but I was waiting for him to identify which are the interior pictures in the packet.
Yeah. So on 215, the bottom left, the bottom right, on 216, the top right, and 217, the bottom left, to 18, the top left, top right, bottom left, and that's it.
Okay, thank you. Any additional questions for the tenant? Yep. Vice Chair Moore?
Thank you. At any time after Scott Properties had your apartment painted, did you reach out to them and let them know that the paint was peeling?
Repeatedly, yeah.
Okay. And did you talk to them about the oil-based paint, painting over it, and that would be the issue?
Did I tell them? Yeah,
Did you
there's
raise
a
that
copy
to
of a
them?
letter in the packet that you have right there that was my conversation with the painter, and I put in writing exactly what the painter told me, and I forwarded that letter to Scott Properties. And he specifically said to me, I could take all the paint off and apply something, then put more coats of water. I could fix the problem, but Scott Properties will not let me do it because they don't want to spend the money and because it's time consuming. And he said, and you'd have to stay in a hotel for 2 days, and they don't want to pay for you to do that either. And he said, so right now, all I can do is paint on top of paint, and oil and water don't mix. So this peeling will continue as
Sorry to interrupt. Did she answer your question?
Yes.
Okay.
Thank you.
That was on page 212.
Thank you.
Any additional questions? Okay. At this time, I will ask the landlord's representative, Jacqueline Gallardo, to come to the microphone. Please state your name and city of residence. You'll have 5 minutes, and you can begin when you're ready.
I'm Jacqueline Gallardo. I live in West LA. Good night, everybody. So this case, we got the request to paint the unit. We did paint the unit. After we painted the unit, the tenant did request it or told us that some paint was peeling. We resent the painter out, which did the repainting of the unit, and that's when the compliance was submitted. We have not heard from the tenant back from that time. It could have been because she was in the hospital. I can't say why. But we didn't receive any notification after the last time we sent the painter to do the last touch-ups there. So it went to compliance, it was granted, and the first time I heard about this was when we got the appeal notice from the tenant, which then I reached out also to the tenant asking her, hey, do you need me to send the painter back? I did not get an answer on that email. So for us, that subject of the peeling paint was taken care of. We hear now that there's a situation happening again. We also spoke to the painter. The painter has told us that he didn't make those allegations. And in the fact, he said that he didn't use oil paint because it was illegal and could be harmful for her. So in no time we have told him not to do something due to money. And I believe that the time that we painted the unit, she was relocated to a hotel for a couple of days. So I could use my rest of the time to rebuttal. Oh, you got any questions for me?
Oh, you don't have a rebuttal. Sorry, I didn't. You don't have a rebuttal, so you have 5 minutes now, and then
Okay.
the commission will question you.
That's the information we have. We went through the whole process. We waited for the appeal. We waited for any objection. We didn't receive anything from the tenants. For us, that subject was closed.
Okay, does that conclude your testimony?
Yes.
Okay. Are there any questions for the landlord?
Chair, a quick one. You mentioned that you sent the email after the second time the unit was repainted.
When I got the appeal of this hearing, I sent her an email, hey,
Okay.
we didn't know this was happening. Do you need me to send the painter back?
After you repainted, there was no concerns from the tenant. You never received anything.
We didn't get anything.
All right. Thank you.
And one question. Just one question, and feel free to look through the packet if you don't remember the date on your own, but what was the last date that the painter was there to complete the job?
The last time the painter was there, and I'm gonna go over
Might be on the
the
invoice.
bills, it's what I could mainly get on that, let's see. Last time I submit a painting bill was December, around December he was in there.
And then you filed for the compliance determination shortly after, and a decision was made on December 21st? Okay. Thank you.
The invoice is page 37. It looks like the painter was asked out on 11/8/23, just so we can correct the dates for the record.
Well, he got paid on a certain day, but we kept going, sending him back to do any type of work that he was missing. Because our priority is to get the problem solved.
Are there, go ahead.
A quick, do you have the packet in front of you? The paper packet?
This,
Yeah, could you turn those pages that we referenced with the tenant, like it's on page 22, 23 through 27 or 26? When you get to that section, let me know.
Are these the photos from the appeal?
Oh, is that what, oh, these are from the appeal. Okay, yeah, these are from the
I
appeal.
I haven't seen these. These are new.
Yeah, the commission would have to, again, make a decision about.
That's
whether or
fine.
not-
I have a quick question on these photos. So my question is, if you look at these photos, do you think these reflect the current state of the paint in the apartment? Because the tenant is telling us these photos were taken in January, and you're saying the last time the painter was there was in December. So when you look at these photos, do you think that these are what the current status of the paint is in the apartment? Just what's your thought on that?
I can respond to that because I have not been inside the apartment. My email was not responded to so that we could go and inspect what was happening, so I can't tell you. For our information that we got from the painter was that it was solved.
Okay.
And did the painter ever tell you that the original paint was oil-based paint?
He mentioned that he could use oil-based paint, but that would have been dangerous for her if she wanted something more durable, and that's why he didn't do it.
That wasn't the
So-
question. The question was, did he say that the paint that was on the walls was oil-based paint?
No, not to me.
Okay. Did he ever sort of give any indication of this needing sort of different type of process that it needed to be stripped down, that they needed to do sort of some additional work in order for the water-based paint to stick to the paint?
No. The only thing he ever said is I could use oil-based paint and that would harm her.
But why would he bring up using oil-based paint if it's illegal?
That's why we didn't do it. And that's why I'm like, what are you talking about? But that's what his reference was.
Got it. And can you turn to page 193 in the book, please? All right. Are these the photos that the landlord submitted with the request for the compliance determination? It looks like 193 through 196.
Yeah, there's some of, yeah. I have them here too. They might show brighter color. I know they had some question about the color.
Do you recall when these photos were taken?
That should have been taken, out of my mind, I would say within the date that that the painter painted, because the pictures are taken literally by the painter when he's done with his job and sent to us.
Got it. So those would have been around when the painter came for the touch-up or the original
No,
painting?
the touch-up. The first time we did the whole unit, the whole unit was done.
Okay, and I also noticed that this unit hasn't been re-registered. Is there a reason why the landlord hasn't re-registered this unit?
Re-registered.
Re-registered with the city.
The tenant has been in the unit for over 30 years, I think. I believe he was registered at the beginning when her tenancy started.
So under the RSO, because the tenant's been there since '96, they don't have, there isn't a re-registration requirement. So at some point when this unit does become vacant, they will have to re-register it. But for this tenant, under the RSO, there wasn't had to be a re-registration form.
Got it. Thank you for that clarification. Any other additional questions from the commission? All right, thank you so much. And Madam Secretary, how much time does the tenant have?
2 minutes and 15 seconds.
Okay, you have 2 minutes and 15 seconds for your rebuttal.
I'm sure that she's going to want to speak too. But I did want to mention that the work that was done by the painter was actually, Jack, you were there when she was there when they came back for the touch-up paint. So the idea that you were aware of the yes.
We can just, yeah, if he's the only one that can testify.
Yeah. Well, a representative then, I'm sorry, a representative from Scott Properties was there, so they were made aware that it was, oil-based, plus the idea that it's 30 years old, it's going to be all oil-based. Lynn did want to speak too.
You have 1 minute and 36 seconds.
I think it's just a legal fact that oil-based paint is illegal, end of conversation. It cannot be used by law. So the fact that anybody thinks that you can just keep painting on top of it, the stuff you put on top will continue to peel. You have to remove the oil-based paint and get down to the wood and then texture the wood properly and then put the correct paint on top of it. That's not been done in my apartment. So if you want to say, is the job done sufficiently? No, it's not, because it's not been done correctly. You just paint water on top of oil and it continues to peel off. So I live with peeling places all over my apartment. The point is, taking $27 off my rent every month, I don't think is sufficient for me to continue living taking that off my rent. If you want to make it a little higher amount of money because Scott Properties doesn't want to pay to do the job properly, that's your decision. But I'd like the job to be done correctly, but if you don't want to do that, then just let me take more money off my rent every month, and I'll continue touching up the spots as they peel off, and I'll just continue doing it myself. I mean, I don't know what else to say.
How much time do we have left? Sorry.
27 seconds.
Okay, really quickly, I wanted to ask for legal counsel. You mentioned something about the way that everything works with the appeals process. The very first time that this was brought to the Rent Stabilization Board, Scott Properties failed to show up to the actual hearing. The hearing, this is straight off of the paperwork from the commission, that we did continue to have the hearing as was necessary, and then it was cited in Ms. LeMay's favor.
That's time.
Why was it allowed to be appealed?
I'm not following what's the issue? Is it, if this is a prior, not this case issue, that's irrelevant, but a party not appearing to a case has no factor in whether they can appeal it.
I'm sorry, say that again?
If a party doesn't show up to the hearing, it doesn't affect their appeal rights for a tenant or landlord.
Well, that's not what it says in the paperwork, though.
I don't know what to tell you. That's not what's happening right now in this case, but...
Well, this is the original case that started this whole thing. That's why.
But this isn't the appeal for the original case. This is the appeal for a compliance determination. So that's not what we're talking about.
Okay.
And just to shed some light on that as well, so the hearing that you're speaking of, that the landlord didn't appear at, it was then administratively remanded, and then the hearing went forward. And so the decision was then still made in her favor, and then the landlord has filed multiple compliance determinations, and this is, I think, the third one. And then it's, then she appealed it. So that's why we're here tonight.
Okay, thanks.
Thank you. Before you leave, are there any questions for the tenant? Okay, all right, thank you.
I have one. We've had a lot of conversation tonight about whether the paint is peeling or not. This commission has one question to answer tonight, and that is when, as I understand it, when the hearing examiner received a request from the landlord that they had complied with the painting, there was the hearing examiner at that point in time had to make a decision as to whether or not they had complied.
Correct.
The tenant did not object and say that they had not complied. So the hearing examiner is faced with that evidence. Why did the tenant not object?
That's what I said in the very beginning. I'm not sure of the timeline of this because I believe that I was under the impression that we had submitted it correctly at the right time.
The compliance decision, their request was filed in November. A letter was mailed November 29th, and there was 10 days from that point in time, and this was filed in January, the appeal. So I'm just after the compliance decision. So really my question is, why was there no objection to the request for a compliance?
I think the 10 is
That's
raised.
literally just the one question.
She wants to respond.
In November 29th.
One moment,
One moment,
We're
please.
going to get the microphone.
November 29th, I was not home because I was still in the hospital. And that was when I came home from the hospital, then I filed an appeal. And I went down to the city in person and I filled the paperwork out and I took pictures with me. But I told them that I had not been able to do it in their time frame because I was in the hospital.
Thank you. That actually answers my question.
All right, I don't believe there are any additional questions for the tenant, but we do have a question from Commissioner Rory to legal counsel.
So my question, what I want to ask after I heard everything was, if the commission deliberates, as we're about to do, and we adopt the resolution and staff's recommendation, when can the tenant reapply for another request for rent reduction because of peeling paint? And can the commission modify that period of time or reduce it in any way to shorten it?
So under the regulations, a party that files for a rent decrease application, this is a 6-month window, but this original application was filed well over 6 months ago. So the tenant would just need to follow the procedural process first of notifying the landlord that there are issues in the unit, just as you would for any other sort of maintenance problem. And then if after that 30 days, the landlord had failed to cure, they could then file the application after that period. So as of right now, there's no bar for them.
They could do it tomorrow.
After providing landlord with the notice to fix it, but but they could start this whole process tonight.
And is there a cost associated with that application, or would it be waived for this tenant?
I believe that would be waived because she's a senior, yes.
Thank you.
I have a follow-up question that builds on what Commissioner Rory said and your answer of the 30 days notice to let the landlord know. Would providing the commission pictures and letters in a packet in January that qualify as over 30 days of notice, that because all that would have been sent and is available tonight to the landlord? It's not actually saying fix it, but it's saying, hey, I have a problem on my, I mean, that would be a decision the hearing examiner would have to make, I imagine.
Yeah, I would just say, I don't want to make a pre-judgment. That's for the hearing examiner to decide whether or not the tenant has satisfied their notice burden, but there's an argument there.
Thank you.
Chair, before we deliberate, I think we need to decide whether this new photographic evidence, right? Because I don't feel comfortable commissioners keep referring to these new photos.
Agreed. I was actually going to ask legal counsel about the process for that. Do we need to vote, or is it simply we can just ask if everyone wants to and sort of do an informal poll on whether we want to consider the evidence?
Yeah, so it would be essentially like just kind of like a straw vote, but there would have to be discussion about why the tenant could not, with due diligence, have submitted the evidence at the time it was required. So once that discussion or deliberation's been had, then it could just be an informal kind of like straw vote. I don't think you have to take a formal motion or something like that. And if all the commission or a majority of the quorum finds in favor of it, you can then consider it, or if not, it can't be considered.
Great, thank you. So I will pose that question to my fellow commissioners on whether we are going to consider the evidence submitted, the photos and the email submitted by the tenant that were in response to this appeal.
Sorry, correct. It was attached with the appeal application.
Got it.
But isn't the real question, I think this is the same thing, but just wording it more specific to the point, is do we, did the tenant provide us evidence or a reason for why they were unable to provide evidence at the hearing? and my opinion on that might be different than others, but I think that's the question we really have to figure out, and then we will decide what evidence, if any, to weigh. But first of all, we need to convince ourselves, or we all need to be convinced of the fact that there was something that either kept her from providing that evidence or not.
Got it. And she said that she was in the hospital during that time period. And so if the commission accepts that as the reason, let me know if you are willing to accept, if we're going to admit this evidence in order to consider it for this appeal tonight. And I'll start.
Chair, if I may, I'm quick. I would not consider the evidence. My tentative, subject to further deliberation, is to adopt the resolution and allow the tenant to file for another rent reduction immediately. That's just my leaning, so I wouldn't even need to consider the new evidence.
Okay, Commissioner Kirpies.
So I think we have two options. We have the option of not considering any new evidence and just weighing the merits of the case, and we could make a stipulation that she could immediately waive. Oh, actually, we don't even have to do that because it's already been 6 months. So she could file a motion or file something with her landlord, tell him 30 days, and then go through the normal process again. And then the other option, I believe, would be to. I don't like taking evidence just right here because I'm not under oath. I have no reason to doubt anything that Ms. LeMay said, but just to make it across the board how we treat other cases in front of us. If we were to go that route, I think we would remand it back to the hearing examiner to decide, and then they could make the case whether she was in the hospital or not. And if the hearing examiner determined that, okay, we'll allow you to provide evidence, then he could weigh the evidence there. But we gave them an opportunity at the very beginning of the evening to kind of say that last sentence that she said. They didn't, and they far beyond time, and it's not under oath. So that's what I would recommend, is that we remand it back to the hearing examiner to determine whether she was able to, whether she received the notice and was able to respond due diligence.
Vice Chair Moore. And I noticed that everyone's sort of doing their analysis of the case and decision, and also on this evidence. Don't feel pressure to do that if it's going to take longer for one. Right now, if you just want to say if you would be willing to consider the evidence, I think that's sufficient.
I'm going to say I'm not going to consider the evidence on this. I don't think that it's fair to consider new evidence from one party and not the other.
Okay, understood. I am satisfied with her response that she was in the hospital and did not receive notice. And when she was out, she submitted the appeal. And so I would be willing to consider the evidence. Commissioner Bass.
Yeah, I mean, it took us an hour to get that answer, and it was not part of the appeal. Had the appeal said, I could not object to this because I was in the hospital, therefore I'm appealing, I would have looked at this very differently. But because the entire argument was about evidence and not the reason it wasn't objected to, I am not inclined to consider the evidence.
And Commissioner Topchin.
I was going through the evidence. I just wanted to see if there was any mentioning the tenant was in the hospital as the tenant testified today or stated. Because if I can't really find anything, but to be consistent with all our previous appeals, when we did not allow new evidence, I would probably be consistent with the Commission's position in the prior cases that we should not consider the new evidence, and also considering the fact that the tenant can refile at any time after this. So, no.
Okay, so it doesn't look like we will be considering the new evidence that was submitted January 26, 2024. And so with that, we can move on to deliberations. Is there a volunteer that wants to kick it off? All right, Commissioner Bass.
I have a lot. I want to speak because I have a lot of sympathy for what's going on here, in that I think that a lot of the stuff we've just discussed is government process stuff. And I am encouraged that the landlord, and I tried to get the quote down exactly, but I didn't, but that they suggested that their objective is to resolve the issue. I'm heartened to hear that, and I hope that that is true. I have every reason to believe it is. So at the end of the day, this commission can only really decide, did the hearing examiner make a reasonable decision, a decision a reasonable person would make with the evidence in front of them? That's the question. And in this case, the hearing examiner was told by the landlord, we painted, and heard nothing on the other side. Well, a reasonable person would say, well, yeah, they painted, if that's all the evidence they have. I'm hearing that you were in the hospital, and as I alluded to a moment ago, if that would have been the argument that came before us tonight, that would have been a different conversation. But that isn't the argument that came before us tonight. This original hearing was filed October 10th, and we've already kind of alluded to this as well. We have a 6-month waiting period before you can file for another rent reduction. That passed a couple of weeks ago. Again, the hearing examiner is going to have to make this decision, but if I were the tenant, I might suggest that to the hearing examiner, and it's up for you to make all of the decisions you want to do, that, look, they got this evidence in the mail in January before this hearing saying that the paint was peeling. And so they've been noticed. You have to decide if that's strong enough, or if you want to give them another 30 days, maybe they can resolve it before then. That's all for you folks to figure out, not for us to do. But I think it's very close to being able to prove that there's paint. From the pictures I've seen, it seems like you have a reasonable argument that the paint is peeling and could perhaps, I'm using vague language because should it get appealed before us again, I don't want to have already prejudged this. I'll have to look at it new. But there's a decent argument there that the paint is peeling. So the question comes down to just procedure stuff. And the hearing examiner was told it was painted, no evidence otherwise. It's simple for me to say they made a reasonable decision. Would they make the decision that it needs to be painted again if you filed again? I think that's the next conversation that needs to happen. And I'm sorry that that's more meetings and more process, but I just think like we time people on how long they speak, we have to just follow procedures so everybody gets a fair shake. So I want your unit painted. I get mine painted every year because I know those rules, well, not every year, every time it's required. My landlord's afraid of me. Anyway, so I get it repainted because it's important to me, and I know that that's important to the tenant, and I think legal counsel's going to correct me on something. 4 years, yeah. Oh, I thought you were correcting me on something. I said every year, but I meant every time it's required, and because I forgot the exact amount of time. I have a Google sheet at home that I follow all this and put dates down. So with all of that to be said, truly on just a procedural grounds, I'm going to have to vote to uphold the hearing examiner's compliance decision, and I will also say hope this just gets resolved without you all having to go to more meetings. Thank you.
Thank you, Commissioner Bass. I'm actually going to jump in because I think I sort of see where this is going, and I want to see if I can convince my colleagues differently. And so I don't believe that there was substantial evidence of record to support the decision. Even looking at the photos that the landlord submitted with the request for compliance on page 193 to 197, and then comparing those photos to the photos that the tenant originally submitted back in July. So back in July, there was, there was the notice that went out because the landlord at that point had also applied for a compliance determination. There was a decision by the hearing officer at that time that the photos of evidence of record did not support that the landlord had complied. And that decision, most of that decision is on page 35. And so there is a page that's missing, but I did get it from staff, so I can sort of just say what that says. But essentially, the hearing officer said that the compliance determination was denied. And what the hearing officer did was, he said, upon comparison of the photographs submitted by the owner and Ms. LeMay, it appears that the paint is peeling, and Ms. LeMay's objections also indicate that the painting was done, but is now peeling off the doors and woodwork. And so based on that, based on comparison of the photos from the landlord and the tenant, it looks like, it wasn't granted then, and then they applied later. And then, as while we're here, it was granted. And so, from my perspective, it seems that the hearing officer's process is to compare photos of record to make the determination on whether there's, compliance. Here we have the landlord's original photos that they submitted back, like I said, pages 193 and 197. And then we have the photos that they submitted for this compliance determination, which are pages, it's like 38 through 42. They might be in here again. But they're not even of the same, the photos aren't of the same parts of the apartment. And so, from my perspective, if the hearing officer, the prior process was to compare photos of evidence, then why not compare the photos with what was previously submitted and of record to what the new evidence was, to make sure that the spots that had issues were actually corrected? And because I don't see photos, essentially before and after photos of the same areas, I don't think that a determination can be made that the work was done, especially since I don't have photos of the work that was done based on the photos that the landlord originally submitted. And so I think based on that, I'm not sure how we sort of got to there being compliance, or that they did sort of complete those repairs when there's nothing showing that. Is there a question, sort of what pages?
They're the same.
Oh, did I give the wrong number? Oh, here, let me give you the right number, sorry.
Well, yeah, I'm not sure why they're in our packet twice, but pages 37 through 42 and 192 through 196 are the same.
Oh, sorry,
in our packet.
Oh, sorry, 215 through 222. So
Sorry to
it's,
interrupt you.
No, thank you. I just don't want to, I'd rather folks know what I'm talking about than to not. So thank you for that. And so again, photos 215 to 222, correcting the record, were submitted by the tenant back in July for the second compliance determination that was denied. And so those areas where, and she pointed out which ones were peeling. She said it was sort of the bottom two on 215, et cetera. We don't have those same photos by the landlord on those prior pages that I said, 193 to 197, to make that comparison on whether the work for the chipping was actually completed. And so even looking at like 215, like the bottom right corner of that cabinet where it's peeling, we don't have sort of the updated photo where the landlord's evidence that this issue was corrected. And so that's why, it's sort of part of the reason. And then also looking at the history of this unit, there was water damage back in 2016 that wasn't remediated until essentially the issue that we have before us. And so it was a prior owner, or it might have been the same owner, but anyways, in 2016, she sort of complained that there's water damage, my walls are horrendous. She asked them to fix it, they didn't. In October, she requested that it be painted. They told her we would get to it on October 28th, it wasn't done. They never reached back out to her, she reached back out to them, and this is all in sort of in the emails that are going back and forward. And so I don't think that there's sort of merit to the argument that the landlord was sort of tried to do all of these things when this issue has essentially been present since 2016. And even at the point where they told her, hey, we're gonna get it done, it was multiple months in between before they even reached out to her again to begin setting up this process happening. There's even an email on page 91 where the landlord says, it's an internal email between themselves, that there is severe water damage to this unit. And that still wasn't enough really to get anything moving until, essentially she had to come before us for that to happen. And so the standard is that the landlord has to submit credible documentation that creates a rebuttable presumption. I don't think they've met the standard of submitting credible documentation, so I don't think the rebuttable presumption exists, and based on the same reasoning that I already gave. And so with that, for those reasons, I would say that I don't believe that there was substantial evidence of record, and I would support a remand for all of the evidence to be considered, and with the notes that I've sort of laid out today. So with that, does anyone else want to go next?
Speaking unless somebody else who hasn't spoken wants to even. I would, I disagree with your reasons, but I think we're all trying to get to the same conclusion, that this be resolved. I think that if we wanted to remand it, we could simply say that we believe that she may not have had an opportunity to respond to that first letter for when the decision was supposed to be made, and that because she was in the hospital or whatever, we can leave it up to the hearing examiner to make her prove that, bring a receipt that she was at the hospital. Then she can bring all of this other evidence, and the landlord would also have an opportunity to provide their evidence that they've already provided here, or provide more evidence. Maybe they do have other photos. I don't know what they have. I don't want to speculate, but both of them can have this argument, or this discussion, the discussion that we're having here tonight, without the evidence. They could actually have it with the hearing examiner with the evidence from both sides. So I think that we could remand it for that purpose, or to allow them the opportunity to have this discussion.
Well, I too disagree with your reasoning, but I'm happy that we arrived at the same outcome. Does anyone else want to go next?
Question for staff. Is there any time difference between a motion to remand versus adopting the resolution and allowing the tenant to refile for a rent reduction in terms of the next point they'll get in front of the hearing examiner? Is one faster than the other?
I don't know if I can necessarily one's faster, because it's going to depend on the hearing examiner's schedule. It's going to depend on when notices can get out. It's going to depend on when the parties are available. So I don't know if necessarily one is faster than the other, but I would also caution against that being a reason for making a decision. I think that the decision has to be whether or not there's substantial evidence to support the hearing examiner's decision in this case. If there wasn't, for example, and then the discussion of, is it better to reverse or remand, or something like that. But I would I would caution against making a decision based on what's a faster approach, because
I just kind of wanted to know if there's a major difference, but it doesn't sound like there is. Is there a difference on preserving the tenant's rights to the $27 decrease? If we remand, is there a way for the hearing officer to decide that upon further review, it turns out the touch-up paint wasn't done the way I thought, therefore I'm going to allow the $27 rent reduction to remain in place? In other words, could they backdate it more, or is there a different date that applies if we do a remand versus allowing a new refile?
yes, because as of right now, the rent decrease is in effect because it's from the original decision. So, I mean, if you remanded it, it would remain in effect, versus if you adopted, for example, the hearing examiner's decision, then the rent would be restored until a hearing examiner issued a new decision. But again, I would also caution using that as a justification for a decision, because again, the sole question is whether or not, as Commissioner Bass pointed out, is there reasonable evidence supporting the hearing examiner's decision? And I do just want to point out that, as I've said before, it doesn't matter if there's contrary evidence in the record. That happens all the time. Substantial evidence just requires that a reasonable person could look at the record and make that same decision. And I think that Chair Wright makes fantastic points, and I would never want to go against her in court. But I also would very much caution against creating standards, for example, of how a hearing examiner should be reviewing compliance determinations. And I think creating a standard of essentially every single time now a party has to submit the exact same photos of before and after, I think creates a very dangerous precedent. Just maybe not dangerous, but I do think that you're creating essentially a precedent of how a party has to prove their case and how a hearing examiner has to rule on it. So I do want to say that, again, it's just substantial evidence, and if the commission can find that there is substantial evidence, and again, it's not a quantitative matter, it's a qualitative matter. It can be, for example, they just submitted an invoice, and the invoice, said repaint the entire unit. In some factual situations, that might be enough. In others, it might not be. One photo might be enough. In some cases, one might not be. Right? It's a very fact-intensive analysis. So to the extent that the commission is considering alternatives. I'm going to be the pest and just remind you of the standard.
I just have a comment on that, sort of regarding the standard. I guess sort of my view on looking at that is the last compliance determination decision, the hearing officer specifically referred to the chipping paint. And again, we don't have that in our binder for the rest of the commission to see, but I saw the decision from the file, and it talks about the chipping paint based on the photos submitted by the tenant. And so to me, it's an apples to apples of, if this was the reason why the compliance determination was denied, in order to get out of that, then you should be speaking to the specific reason why it was denied. I don't think that creates a standard, but I don't want to create a standard. I'm just saying, for this specific case, it made sense to look at the same pictures, because that was the reason why the compliance determination said no, I guess, previously, and while we're here, so.
Chair, I've already spoken, but I do want to point to page 37 of the right after the compliance determination. There's an invoice dated in November that does show that touch-ups were done that goes in addition to the photos. So that to me is evidence beyond just the photos that the work was done.
Okay. I saw the same evidence and came to a different conclusion, but thank you for bringing that up. Is there anyone else that wants to go next, or should I call on someone that I'm looking at now? No. Vice Chair Moore.
Oh, this has been a tough one. My inclination, I've really tried to hear everyone here, and I think I'm going to vote to adopt the resolution. But I do hope that whatever happens after tonight, that you all can work together with the landlord. Scott Properties, the representative, seems very apt to fix things, and I'm not sure, we don't have evidence as to going back and forth since everything has happened with appealing, but I do hope that hopefully you guys can resolve this outside of here as well.
And thank you. And Commissioner Rory, did you want to go? Did you already go?
I feel like I talked a lot tonight, so I'm okay. I'd be curious to hear Commissioner Topchin's thoughts.
Nobody wants to. Thank you, Chair. The reasoning was really great, and but where I agree with the legal counsel is that tonight's decision cannot create a different approach or different standard, or create a precedent of how we're going to look into the evidence presented by the landlords for compliance determination. I remember those cases that we looked into, and there was one receipt or one invoice would basically considered substantial compliance in all the cases we looked before into. So I don't really, although I understand the passion, I kind of see and I agree with you, the way that you looked into that and how you presented your thoughts, your argument. But putting the hat of the Rent Stabilization Commissioner and having this kind of a tunnel vision that tells me I cannot vote any differently, look in a different way into this case, just because I feel passionately, I feel passionate for the tenant, and I agree with the tenant, and I believe that the management and the landlord should have done a better job to address those things. But I cannot change the standard. I cannot change the, I cannot just completely ignore the evidence presented by the landlord for compliance determination. So if that was accepted by the examiner, that was sufficient to prove compliance, so then I cannot disregard that. And although, you know, what Chair explained, and I see and I agree with the reasoning, but I'm going to support the staff's recommendation. Another thing is what makes me feel a little bit comfortable that the tenant will have an opportunity to file a new application, and that would be a de novo, obviously, it would be a new hearing, right? So that's not good, that's been completely different review and the look into the evidence. And regardless what will happen tonight. So I would say at least that gives the opportunity to think that this issue will be resolved, because we really want this to be resolved for you. And with that said, so I'm going to support the staff's recommendation. Thank you.
Okay, thank you. Has everyone had a chance to, Commissioner Kirby's?
So I believe, and I think most of us do, that there was substantial evidence in the record tonight to determine that the hearing examiner made the correct decision based upon the evidence that the hearing examiner has provided. Most of us, not all of us, agree with that. However, if Ms. LeMay did not have the opportunity to provide evidence, counter evidence at that decision, in that decision process, which at the very beginning of the night I started with questions about how the individual gets notified. Is it just one letter? Is it from the city? Is it from the landlord? Is it through the U.S. Postal Service? Which, remember, this is in November during holiday seasons. I mean, I've lost a letter just a couple weeks ago. People lose letters in the mail all the time. I think that even though the hearing examiner, I think I'm going to remove that we remand this to the hearing examiner to, first of all, to completely throw out everything that was in the first hearing on the decision, but to start over, both of them present evidence, the hearing examiner make a determination based upon that evidence, and that way both sides are afforded the opportunity to provide. But I think the first question that the hearing examiner needs to decide is whether she can show some evidence that she was in the hospital at the time. If she's able to do that, then I believe that the hearing examiner should proceed with the questions of weighing the evidence again. This preserves the $27. It preserves the situation how it is now. It doesn't penalize anybody. It doesn't make anybody wait longer. The landlord can, as they've said earlier, if they would have known, they would have fixed it. It gives them an opportunity to go fix it before the hearing examiner makes the determination. So I think that's the fairest.
Can I ask a question, Chair? As a clarification, if this is remanded, would that be a de novo hearing that would be open for any new evidence to be submitted?
Are you saying, is it a de novo hearing before the hearing examiner?
Correct.
The remand hearing would be based upon the instruction of the commission. So could be as narrow or as broad as the commission instructed it to be.
So it would just be that it be the decision of whether the compliance was met or not, just the compliance.
I have a question. I think I'm probably agreeable to your motion. Is it a requirement for what your motion is for the tenant to prove sort of why? Is that a threshold issue? The tenant would first need to prove that why she didn't respond, and then the hearing could proceed, or?
Yeah, but all I really wanted is just for her to make her statement that she was in the hospital valid to someone needs to just see the invoice or something. I mean, I'm not talking about a high standard. I'm just talking about that she needs to present him a reason that she presented tonight, and then move on to the question of what compliance.
I would be agreeable to that without that contingency, because if she can't produce it or for whatever reason, then it seems like it would sort of stop there and then would come back to us. And so I think for us to remand it, we have to sort of believe that there was, a good reason why she didn't attend, for the evidence to all the evidence to be submitted. And so without that contingency or stipulation, I'd be agreeable to that motion.
I have a question. Is the knowledge that the tenant was in the hospital to us tonight, is that considered new evidence?
Yes, that would be new factual evidence submitted tonight.
But we voted not to, or we said we weren't going to vote on
accepting
new evidence.
That was on the photographs, right? But presumably, any new facts or matters have to meet that same standard And I think to what Commissioner Bass was saying is that in the appeal, if the true reason that evidence wasn't able to be submitted on objection was she was in the hospital, putting it in the appeal was the time to do it, and not during a unsworn testimony portion of, you know, an oral argument at a public hearing. Is that accurate? Okay.
I say sure because you said it a lot
So
better
I'm
than
just,
I would.
I'm just wondering if, Commissioner Kirpies, if we were to go back to the examiner and remand this and say, well, you need to look into, you know, accept evidence from her on her status of being in the hospital at the time, is that us accepting the new evidence here in order to make that decision?
Right. Yes, I think from a technical standpoint, if you are remanding it for consideration of whether or not the tenant had essentially a just cause for not objecting, that would fundamentally require that you accept that premise tonight.
And so would it be illegal, or would it be a reason, a cause for them to, the opponent to appeal simply because I made that part of the motion, that she would first have to prove that before the second question could be answered?
Well, I want to be very careful on the record to say anything, but I would caution that, as I've said this before on the open record, and I'll say it again, which is the whole purpose of having a high burden, for example, such as a party needs to prove why with due diligence they could not submit a fact, evidence, a matter at the time it's supposed to be. It's a due process issue, and it is because the opposing party should have the right to be able to examine, refute, address with sufficient time new facts, evidence, and matters, and not on the spot during a public hearing, which they have a limited amount of time, don't have access to their records, to kind of satisfy the inquiry of a legislative body. And so the whole point of making sure that everyone submits evidence when they're supposed to be is that everyone has had their due process to address it, rebut it, and again, the hearing examiner did not have that information in making their determination. And so accepting evidence the hearing examiner did not have fundamentally is changing the decision, because it's adding new things that aren't a part of the decision. So whether legal or not, I will just say that, as I've said before, the new evidence matter is one of due process that the commission should just be, just keep in mind. That's the purpose.
So I'm going to keep my motion the same. That way, both sides can review the evidence of whether she was in the hospital or not, and then decide, then the hearing examiner can decide whether to move on to the next question.
And so under your motion, if the initial evidence or threshold isn't met, then the examination would stop at that point. There wouldn't be a consideration of any of the photos, et cetera?
Then she would have lost her appeal.
Okay.
Chair, do you mind just before taking the vote, making sure that everyone's certain on what the motion is? Because I'm not particularly certain. I just, and in the event that this motion does pass, it would require me to have to update the resolution. So part of this is also trying to understand so maybe before doing a formal motion, it's worth doing a informal kind of straw poll to see if there's appetite for this kind of remand, because the actual motion will probably have to change, because I'll have to instruct me to change what the resolution is. And with another appeal tonight, I don't think I can do that tonight. So you'd probably have to instruct me to bring back at the next meeting, which I guess could be the 9th, a updated resolution for remand. But I think before digging into specifics of the remand, we should just informally determine whether there's even appetite for that.
And Commissioner Kirpies, can you
That's my
say the
informal. That's my
components?
informal. Yeah, my suggestion.
Can you repeat it?
Oh, that we remand it back to. One option would be to remand it back to the hearing examiner for the reasons that to validate that she was in the hospital unable to present evidence, or wasn't even aware. If that can be determined, then move on to a determination decision process where both sides would have the opportunity to submit evidence to show that the work had been done or not been done.
Okay, would the hearing examiner sort of need more like specifics regarding the type of proof she would need to submit in order to show why she didn't appear? Because I don't think we asked enough questions, like we don't know if she even received the notice, so I'm just sort of wondering are we getting into some sticky area by sort of requiring this, that's sort of a vague amount of proof?
Yeah, I mean, I would think, well, again, the tenant didn't, at least in the appeal, has not raised that. It's not a notice issue, other than she is saying tonight that she was in the hospital, and I don't think we know the duration. I don't think we know, was it a day, a week, 6 months, 11, whatever it is, we don't know. That's a factual question. I think that if you are going to do a remand, that especially for something that is this particularized, the instructions would have to be clear. And so from what I'm understanding is Commissioner Kerpes is wanting kind of two things. One is a threshold issue for the hearing examiner, which is essentially proof by the tenant that during the entire period, the 10-day period during which the tenant had the opportunity to submit evidence for objection, that she was in hospital or in some sort of inability, just cause for not being able to timely object. If that threshold is met, then I think Commissioner Kerpes is saying he would want a brand new hearing where all parties can have every opportunity to address whether or not the request for compliance determination can be satisfied. Is that essentially it?
Essentially, but it's a much higher bar than what I was imagining, because really just want the opportunity for the hearing examiner to decide. I mean, just because you come back on day 9 doesn't necessarily mean you're going to open your mail. I mean, you're coming from the hospital. You're coming from a long trip. You're not going to go through all your mail the first day. So I don't want to set any specific like that. She made the comment, if she can validate that she was in the hospital. When I asked earlier tonight, did you ever receive the letter? They couldn't say whether they received the letter or not. They didn't remember seeing anything that worded it like this. So it's kind of up to the hearing examiner. If it's the evidence provided, and if the landlord says, I know I saw her there at the house 10 days, all these days, every single day, that would be something that the hearing examiner would weigh.
Okay, I think we can take the straw poll. I think I'll ask it sort of two ways, right? Is there an appetite for remand? And then if so, then the question is based on, Commissioner Kerpes' sort of rationale, where there's sort of a two-prong issue, as opposed to just remanding it and letting the hearing examiner sort of do what they do as we've done in the past. So sort of the first question, it'll be a part 2. Is there an appetite for a remand?
Yes. For the reasoning provided by Commissioner Kerpes, I'm fine with remanding for the additional review.
Okay, and then Commissioner Bass?
My heart is with you, Commissioner Kerpes, but my head is not, so I would not support that.
Okay. Vice Chair Moore?
I will not support it either.
I'm going to guess you're going to support your own motion. And Commissioner Rory?
I wouldn't support a remand for de novo review, and I really am wary about supporting any remand for having to prove up medical histories.
Okay. All right, and I would have been okay with the remand without the threshold. I guess it's of no consequence, because I don't think we have it. Do we have enough? No, it was 1, 2.
It was 3-3.
3-3.
So 3. So if it was, so if it was a motion, 3-3 would fail.
Okay. Okay. All right. Thank you. Are there any additional motions?
Having just seen that straw poll, I think I see where things are. So I move to adopt staff's recommended resolution. I don't have the number in front of me if it's important to read.
24-646.
That would be the one I support.
I'll second.
All right, we have a motion and a second. Madam Secretary, roll call, please.
Commissioner Bass?
I'm sorry, Commissioner. Okay, then aye.
Commissioner Kerpes?
Aye.
Commissioner Rory?
Aye.
Commissioner Topshin?
Aye.
Vice Chair Moore?
Aye.
And Chair Wright?
No. Okay, motion passes. Do we need a break, or can we power through the next appeal? I'm fine going through.
I need a break. I'm sorry.
All right, let's take a 5-minute break, and when we come back, we will take on our next appeal for the evening. Meeting is back in session. We are picking up with our second appeal for tonight, D4817. So I understand that both parties are present this evening. The first party will be the appellant. You will have 5 minutes. You can start making your way to the podium. Once you arrive, just let me know how you want to divide your time. And we'll have you begin right after the staff report.
Thanks, Chair. I'm a little nervous for this item after the last one, so we'll see how this goes. But so good evening, everyone. My name is John Adalizio. I'm the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. And this appeal hearing tonight results from a hearing examiner's decision determining that a $200 monthly fee for garage storage is not a side agreement as defined under the Rent Stabilization Ordinance. So at issue in this appeal is a provision of the lease agreement which provides that the tenant shall pay $200 per month for garage storage. And at least during the hearing, there was no dispute between the tenant and the landlord that this is a separate storage fee that's charged to tenant and that the tenant has paid that storage fee. And so the only issue considered by the hearing examiner for purposes that's relevant to this appeal was whether that monthly $200 storage fee was an unlawful side agreement. Tenant filed the appeal, which claims the decision is clearly in error, is not reasonably supported by the findings made or evidence in the record, constitutes an abuse of discretion, and is contrary to the law. Staff believes that there is not substantial evidence in the record to support the hearing examiner's decision, that the hearing examiner incorrectly interpreted West Hollywood Municipal Code Section 17.32.090. The RSO prohibits side agreements charging a fee or rent, which the RSO defines as an agreement that is not part of the underlying or primary oral or written lease agreement that establishes the base rent. Rental units that are subject to the RSO have a maximum allowable rent, which is the maximum monthly amount that may be actually demanded, collected, or received by the landlord as rent for any rental unit covered by the RSO. And that MAR is determined by the base rent plus any permissible rent adjustment, which is just an AGA, annual general adjustment. Side agreements allow a landlord to circumvent the RSO by allowing the landlord to separately raise the costs of the fee charged in that side agreement in addition to any permissible AGA on the rent. The evidence in the record makes clear that this $200 per month storage fee is separate and an additional charge from the rent, and thus it is a side agreement that is prohibited under the RSO. Accordingly, staff believes that the hearing examiner should be reversed on this issue. And since this monthly $200 storage fee is an unlawful side agreement, the landlord has therefore demanded and accepted rent in excess of the MAR in violation of RSO. And the hearing examiner correctly determined that the unit's MAR is $1,995, commencing on April 1st, 2022. And since the MAR has been the same since the initiation of the tenancy, the overpayment calculation is simple, which is the $200 times the 24 months that it's been, which is $4,800. Therefore, staff recommends adopting Resolution RSC 24-647. You as the Commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The Commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the Commission to make sure there's substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there's also evidence that could support a different outcome. The Commission does not substitute its judgment for that of the hearing examiner or reweigh evidence. As it relates to questions of law, the Commission applies an independent standard of review to those conclusions. Thank you.
I have a question for staff. Is there a recommendation regarding refund versus an offset based on where your recommendation is? And what I mean by that is the landlord refunding or the tenant offsetting sort of the rent until it would meet the overcharge that's identified in the staff report.
By offset, do you mean like withholding the rent?
Correct.
I would think that if there's a preferred method in terms of refund or withholding, I would say that that would be probably up to the tenant how they wanted to implement that.
Okay, thank you. Are there additional questions for staff of Commissioner Kirby's?
So just to summarize, I want to make sure that I'm understanding correctly. The tenant moves in, finds an apartment, talks to the landlord. Landlord says, yep, the apartment's 1995. Whoever initiated, I don't know, but the landlord also says for $200 more, you can rent some garage space, some storage in the garage. They both agreed to it. They both signed to it. There's no hidden. It's right there in the lease. There's been no increase or no attempt in the record to ever increase that amount. There's been no AGAs to be applied to either of those amounts in the record. And then for some reason it gets to a hearing, and the hearing examiner is asked to make a decision on the MAR, decides that it's fine. It is a side agreement, I think is what they just determined. Or no, it is not a side agreement. And now staff is asking us to say, yes, it is a side agreement and it's illegal. But instead of just saying this has to stop, and you can't have this agreement any longer, landlord, you take the garage back, the garage space back, and tenant, you stop paying the $200. We're saying, you're recommending that we now reimburse or have the landlord refund the tenant $200 a month since the time that they started paying it, even though they got to use that garage space. Is that the recommendation?
Yeah, well,
I know there's different.
As you spun it, yes, but the landlord, or sorry, the tenant applied for an overcharge in rent. So that's part of this consideration, is whether or not the landlord has retained rent in excess of the maximum allowable rent.
So is there anything in the record that says the tenant asked to no longer rent the garage storage space and the landlord denied, or is that just not in the record?
That the tenant asked to stop using the...
Yes, said, I don't want to pay for that garage space anymore. And the landlord said, nope, it's in the lease, you have to pay for it.
That I don't know. I'm not aware
of
if that fact is in the record.
This one's going to be a tough one for me.
There was something that Commissioner Kirby's just said that doesn't ring true to me, and that is that there has been an attempt to increase the rent, increase the maximum allowable rent, the MAR, but that the hearing examiner decided that because it had not been re-registered, that was all. They already issued a decision that had to be refunded. So with the argument that they've now tried to raise either amount, they did try to raise one.
Okay, so
the 1995.
They did try to. In what year?
The rent without the storage unit. They tried to raise that portion.
Sorry, yeah. Okay, that's all right.
Just to make sure it was clear. Yeah.
And then, are we considering the parking or the storage like a part of like a housing service? That way, even if we say yes, it's a side agreement, yes, reimbursement, tenant still has use of it?
Yes, it's a housing service.
Okay.
And so this is, and let me provide more context here, because this kind of happens every time we have a side agreement case. And so I tried to explain it kind of more thoroughly in the staff report, but this is kind of, I know this can be complicated, but the whole purpose of having a maximum allowable rent, right? I'm gonna go big picture here, is to ensure that the protections of rent stabilization can be enforced. And that is making sure that rents are stable, that tenants aren't going to be subject to spikes that ultimately result in them having to move and relocate, resulting in furthering housing issues, whatnot. And so having a maximum allowable rent is key to the rent stabilization ordinance, and ensuring that a landlord cannot collect, demand, or accept any sort of money in excess of the MAR is critical to this ordinance. Otherwise, it all falls apart. And so what the ordinance says is that all the housing services have to be included in a single rent. And the reason why side agreements are unlawful is because it destroys a maximum allowable rent. Because what it allows a landlord to do is to parse out housing services and say, for example, in this case, okay, garage storage is going to be $200, use of the oven, $50, use of a in-storage laundry, in-unit laundry, $100, but your rent's $1,000. Okay, well, the rent can increase by what the AGA is, so let's say it's 2%, but all of a sudden they get a notice that all of their other housing services are going to get a $100 increase. So the whole purpose is not to abrogate parties' abilities to negotiate housing services, but it has to be done in compliance with the RSO. And a landlord's lack of knowledge of that is their own problem. And so, and I know because this question has come up before, had they included the $200 in the rent, and it was one rent amount, yes, that would be legal because now there is one rent, and only that rent can be increased. And so, but that's not what we have here, right? Factually, it's very clear from the record that the rent is the 1995, and there's a separate $200 fee. This is just within the definition of what a side agreement is, and the RSO prohibits a side agreement. And then I'll take this a step further, which is that there is a mechanism that allows a landlord and a tenant to negotiate adding a housing service and removing a housing service when it's going to affect the MAR. And that is a process that's laid out in the regulations, but it's a process that requires involving the city. And the reason why is because the city is the one that regulates the MAR. And so if you want to add a housing service and charge additional fee for it, or a tenant wants to agree to remove a housing service and the landlord's going to agree to lessen the rent, that can be done. So there are ways to do this, but it just requires involving the city, so that way the city can make sure that the MAR reflects those changes. And that wasn't done here. And so there is a mechanism for that. And so to the extent that the landlord built in a separate fee in the lease agreement from the rent is the fundamental flaw that is just against the definition of a side agreement, which is prohibited. And so I don't know if that helps at all.
Default be for the city's position to be, then it's separate. Like, there's no conflict here in terms of someone either getting a service that they didn't ask for, or paying too much than what they've asked for. Why wouldn't the city's default be, no, your MAR is now $21.95, issue resolved?
Because that's not what the definition of the base rent is, right? And the lease is very clear of what the rent is. So that would functionally be requiring the city to create a new base rent that doesn't exist.
Chair, I have some questions. Because I'm the newest one, Commissioner. Has this issue come up before in your tenure or in recent tenure? And has the rulings been consistent in the past about, because these are, I'll note for the record, these are standard California Association of Realtor forms. These are very, very common forms. So I just was curious if this exact issue has come up before, and what the city recalls or could share about that.
Yes, so side agreements have come up before, and the ruling or staff's position has been the same, which is that the rent needs to be one. It's one rent amount. That's all you can charge a tenant. You cannot parse out separate housing services. You cannot create separate fees. There's only the rent. There's only the maximum allowable rent, and every housing service that a landlord wants to provide a tenant and its valuation has to be included in that. To the extent that this is a form of the California Realtors Association, it's a form and is not tailored to specific jurisdictions. And where West Hollywood, we have a very comprehensive and a very regulatory intensive rent stabilization ordinance, it is then falls on the property owner to make sure that this form is tailored to the laws of the jurisdiction, right, where they're implementing it. So while it is a form provided by the California Realtors Association, that to me, that doesn't lend any sort of credence to the position.
My follow-up question is if the resolution gets adopted and the hearing examiner's decision is reversed and the landlord has to either reimburse or credit the $4,800 and the tenant is allowed to keep the storage, in the future, if the landlord decides to take away the storage for whatever reason, could the tenant then apply for a reduction in housing service on top of the $4,800 they're already receiving?
Yes.
Okay.
Because again, all of the housing services have to be included within the rent. And it's very clear from the lease that the rent is $19.95.
So even though we're saying this was the storage agreement, if we adopt the resolution and we say the storage agreement is part of a side agreement, the storage unit is part of a side agreement, it wasn't properly included in the base rent, we're in theory still opening the landlord up to a reduction in housing service if the storage, which we're saying was part of a side agreement, is taken away.
Yes.
Are there additional questions for staff? All right, wonderful. So we can now begin the appeal. And so if the tenant is ready, just let me know how you want to divide your time, and then state your name, city of residence for the record, and then you can begin.
Hi, I am Carolyn Gehrig. I am the tenant living in West Hollywood. The issue is, as stated, I am renting a unit.
Sorry to interrupt. How do you want to divide your time?
2.5 and 2.5.
Okay, thank you. Go ahead.
Okay, so I signed the initial lease, and I didn't know that it was a rent stabilized unit. I didn't know about any of the rent stabilization provisions, and I was just unaware. I also, as you can see in the whole thing, I also agreed to master metered utility things. I just didn't know. I at no point was under the impression that I could opt to release the storage from the unit. I was under the impression that I was renting it as a whole thing. They didn't disclose to me that they could envelop it as an entire fee and put the additional $200 in and just like raise the rent by $200 at the beginning. I'm bringing this up because if you look at their ledger that was provided by the original landlords, Jensen Capital Management, you can see that the only storage fee listed is mine. But I do have neighbors, and they rent a similar unit. They rent the other garage space, and they did not bill them separately. They also didn't try to raise their rent or charge them registration fees without registering their place in the first year. So there was a difference in the way that we were treated and the way that they parceled, the way that they handled the lease agreements and the way that they handled these fees. So it just wasn't, I mean, it just wasn't really fair. I think that's kind of the crux of it. Also, in the matter of 1995 being the MAR, immediately following the thing with the hearing examiner, the prior landlord immediately began recharging me the increased rate because he said that they had re-registered the unit. So I have been paying $20.54 and not $19.95 for the base rent. to date, which I know that there's nothing in there, but I just wanted to mention that for the
Carolyn,
record.
you're at 2 minutes and 30 seconds, so
Okay.
please let us know if you would like to continue.
Yeah.
Are there any questions for the tenant at this time? Vice Chair Moore?
Hi. Do you remember which month you started paying the 2054?
It was March of 2022. No, not
2023?
No, 2023. Yes.
Thank you.
If you could point to the page in the, do you have access to the pamphlet or the booklet we have? If you could point to the page that you referenced, the ledger that shows the other rents. I think, is it 285 or is that just yours?
I see 339.
339?
339 looks like it's their thing. Hold on. It might be the page before that. I remember looking at, it's 337.
337? Okay, thank you.
All right, are there any additional questions? Okay, seeing none, I will ask that the landlord come to the dais. Go ahead and say your name. Is the landlord present?
Yes.
Okay, you can go ahead and make your way to the podium. Yeah, please come to the microphone if you're able.
Are you able to come up? No.
Oh, okay.
They're not able to come up. They'll be
Oh, thank
speaking
you.
from
Okay,
their seat.
that's perfectly acceptable. Thank you.
In some of the hearing devices, we have hearing assistance devices. Would you like one of the hearing assistant devices? We have devices for here.
You want me to read this, right?
Oh, this is your time to give your oral argument. You're also able to have someone speak on your behalf if you.
And for those watching, we are just working out an issue with our with the landlord to give his testimony.
Yeah, I know.
So are you ready for your 5 minutes?
Yeah, I just have
Okay.
to turn this on.
Okay. One moment, Chair. They're getting their statement that they'll be reading.
Thank you.
Okay. So please state your.
If I start at the top.
So please state your name and the city that you reside in for the record. And then you can begin.
It's okay?
Yes.
Okay. I'm just reading it from the top. This response,
State your name. Your name first. State your name.
my name?
Yes.
It's Greg Barr,
And then what city you live in.
Los Angeles.
Okay. And then you can go ahead.
Okay? But this is from the former owner. This response is prepared by the previous landlord of 322 Huntley. Hang on. Okay. Questions to be determined. A, yes, there is substantial evidence reasonably supporting the hearing examiner's determination. B, the hearing examiner correctly interpreted WHMC section 17.32.090 if it is part of the initial rent the tenant pays from the start of the lease. Interpretation is facially correct. We agree that the base rent is the rent charged to the tenants at the inception of the tenancy. Base rent at the inception was $2,195. Number two, we agree that if side agreements were permitted, a landlord could make every housing service a side agreement and circumvent rent control. That is true for side agreements that are not part of the initial lease agreement and not being paid at the inception of the lease. Additionally, I would understand if it was part of the initial lease, but as an addendum that laid out different charges for various services that could be changed in the future, i.e., storage, $200, parking, $150, EV charging, $75. If this was laid out as an addendum, and then the tenant later on, during the term of its lease, decided to add on one of these services, then yes, it would be a violation of rent control. This is not the case here. Number 3, the $200 is paid. Excuse me, the $200 is part of the underlying lease agreement. At the initiation of the tenancy, the $200 was charged as part of the rent. It does not void the city's rent control. 1, the $200 is not something we are adding. It was part of the initial lease from the inception. As stated earlier, if we were adding the services and charging a fee for them once the unit rent was established, then I understand how there would be a violation of rent control. That is not the case here. Legislative intent. 1, the $200 charge does not go against the intent of RSO. The storage unit is not an inseparable part of the use and occupancy of the unit. The $200 charge has remained $200 for the entire term of the lease and all extensions. Additionally, if the $200 charge was added after the inception of the lease, then it would be an increase that violates RSO. That is not the case here. Number 2, the intent was always to prevent increases in rent in excess of the annual allowable percentage. We have not violated that by initially charging $2,195, parentheses, $1,995 plus $200. Conclusion? Is that it?
You can conclude.
Can I read the rest?
And then we'll just add that time to the
It's
to
only
the
one
tenant.
sentence.
Go on.
There's one sentence? Yes? Landlord recommends that the commission affirm the hearing examiner's decision.
Great, thank you. Hang out there. Let's see if we have any questions for the commission for you. Are there any? We have a question from Commissioner Bass.
They might have questions for you.
Oh, they have a question? Okay, I brought something.
Please give me a second.
Okay.
That allows me, hopefully, to hear.
Okay. Do you want to put it on, or do you want to utilize it?
Unless, I mean, I have hearing aids, and this is connected to the hearing aid.
I can.
I don't think anything goes over.
Here, give me a second.
Yeah, but what do I do?
You're able to listen into the audio with
I'm
it.
not taking the hearing aids out.
No. Can you hear us? Are you able to hear us? No. Okay. Do you want to try? He's having. Do you want to try it? Do you want to try putting, do you want to, no. Do you want to try putting the device in and we'll try it again? And then we'll see if you can. Are you able to hear us? Can you hear us? Are you able to hear us? No. Do you want to try your own? Okay. Do you want to?
I will say that to the extent that you have questions for the landlord, this is the new landlord. They just purchased the property like a couple months ago,
I want to say February of this
February. So I don't even know if, to the extent you can ask a question, but factually, I don't know if they would even be able to satisfy your answer, but
February of 2024?
correct.
Diane, he can hear you when you're standing there asking him if he can. So Commissioner Bass is just going to relay it to you, and then you can. Okay.
Acknowledging that this is a new landlord, which I still think that I should ask these questions, and if the landlord cannot answer them, they can't answer them. But I would like to ask them anyway.
Okay.
Give it to them.
So this is what we're going to do. They're going to ask me the question and I'm going to repeat it out to you and then you can respond. Oh, okay. So you want me to speak into that? Okay. Do I need to push anything down?
And the farther away you are, the better.
The better? Okay.
Test. It's on.
Do I need to push anything down? Just speak. Okay. And then I'll do the mic and I'll stop.
Okay, that's good. I don't know. I'm hearing you.
Okay, can you hear me now?
Yes?
Okay. I'm going to ask you 3 questions.
Okay.
And I recognize that you are a new landlord, and if you can't answer them, that's fine, but I want to ask them anyway. So just let me know if you cannot answer them.
Okay.
Okay, so the first...
slower you talk, the better.
That's a challenge for me, but I will try. I am looking at a copy of the original lease, which is in the packet, and Diane will bring that to you. Diane, if you could just turn that to page 294.
Where is it?
Page 294, section 3. The rent says $19.95. That's correct. The next question I have for you is on page 285. On page 285, it's very small writing, but this is the ledger of your predecessor, I believe. And on there, it lists the rent multiple times as $19.95.
That's pretty small.
It's very small, but I'm essentially asking if...
I say 2295. And, Jesus, I can't. The yellow one, I'm not seeing.
Okay.
I say 2295. Can you see it?
Let me go to the...
Oh, yeah, 2195.
I see that that's what's paid, but on the left side, it does say rent $19.95, storage income $200. That's what I'm seeing. I'm just wondering if that's correct or not.
Well,
If it's your predecessor and you can't answer that, that's fine.
You see what he's talking about? Yeah? Oh, all the way to the, oh no, that's not it.
If you can't see it, that's fine as well.
Okay, well, I mean, I'm trying to read it.
Let's go to the page immediately before, 284. This is the rent stabilization re-registration form from 2023. And about a third of the way down the page, it says move in rent.
Move in rent, 195, yeah, 195.
Okay, I just wanted, is there any reason, this is the ultimate question, any reason to believe these numbers are incorrect?
The 1995?
Correct.
That's what I see. Yeah.
Is there any reason to believe those numbers are incorrect based on your testimony?
Okay, you're asking about the one I can see.
Correct.
The 1995.
As the move-in rent, correct.
Yeah, yes.
Is there any reason to believe that's incorrect?
I see 1995.
Okay, thank you.
Thank you so much. Are there any additional questions for the landlord at this time? Okay, seeing none, the tenant will have, wait first. Is that with the additional 10 seconds that we gave the? Okay, you'll have 2 minutes and 40 seconds. We add an additional 10 seconds since I gave the tenant, the landlord a few more minutes, and you can begin when you're ready. Oh, she needs a microphone.
Give me just a second. Let me set the timer and I'll give you a heads up when I'm ready. Cool. Let me give you.
And you can begin when you're ready. You'll have 2 minutes and 40 seconds.
Give me just a second. I'm going to set the timer.
Oh.
So sorry.
Let me know when you're ready. You've been doing a lot this evening, and we thank you so much.
Happy to help when I can. Alrighty, we're ready to go.
Okay, I wanted, the attempted increase was calculated based on the 1995 NAR. That's the first thing that I have to say. In both ledgers, it's clearly shown as a separate storage fee. I have paid Greg Barr by 2 checks. I haven't received an invoice or a statement or receipt from my landlord of any kind. But I also think that it's really unfortunate that we're in the position that we're in right now, because I do think that he was kind of not really given the full scope of the situation by the previous landlord. And I think that it's a rotten situation. So I would just like to say that. I think it's a rotten situation for both of us, because I think that it sets us off on bad footing. So.
Got it. Does that conclude your testimony?
I think so. I mean, the thing, it's part of the registration. The storage areas, it's part of my unit. I go in and out of it like almost every day, because I keep my mobility devices in there. I keep extra stuff in there. It's right next to my door. It's one of the reasons I took the place. So I guess that's really all I have to say. This is just a frustrating thing, especially now that it falls to a new person. So thank you for your time.
Okay, thank you. I do have a question for you. So staff has recommended that we essentially reverse what the hearing officer decided, and to award you the $200 per month, about $4,800 in total. Were we to go along with staff's decision, would you want your rent to be offset, meaning that you just wouldn't pay rent until that amount is satisfied? or would you want that amount refunded?
I would prefer a refund, truthfully.
Okay, thank you. Are there any additional questions for the tenant? All right, thank you. We are now going to close the public record and begin deliberation on D4817. Does anyone want to kick us off this evening?
Chair, if I may?
Yep.
It's just going to be quick for me. Thank you. As it's stated in the staff's report, the law is very clear that the city council believed that the side agreements they will circumvent the RSO limits in the city, and that's why that ordinance was passed. We had those cases before, and I'm pretty sure that the department receives a lot of calls from the tenants and the landlords about side agreements, and I don't believe anything was done here intentionally by the landlord to violate the law. It's just, I don't believe so. It is a normal practice, and if you even Google sort of a rental or lease agreement formats, you will see this type of clauses and language included already in the format that says, storage, parking, provided or not provided. You check the box, yes or no, dollar figure. So clearly, I don't see there is a kind of a wrong, not the wrongdoing, but intentionally act done by the landlord to violate the ordinance. But the clear thing is that there is a law, and it's very clear. The side agreements are prohibited, and this is one of the examples that the landlord cannot charge anything extra for a service that was available, provided to the tenant at the time of renting. And just because the contract between the tenant and the landlord says that you agreed to pay extra $200, it's still a violation. So, and the reason is because the city's rent stabilization ordinance, rent control, needs to control the MAR, the maximum allowable rent. And that's the only way the rent control can, obviously the department can control the rent. So therefore, I believe that the examiner erred in this decision, in the findings, and I would agree with the staff's recommendation to reverse this decision of the hearing examiner. And that's pretty much it, unless I had my note. And yeah, that's it. Thank you, Chair.
Thank you. Any additional volunteers? All right, I can hop in. I think that this was sort of well explained by staff. I certainly appreciate you all putting the ordinance in there so I could look back at sort of what staff's recommendations were going into the RSO and sort of the reasoning. And I think it's spelled out very clearly on page 390 that staff, essentially told City Council that if we don't, make sure these side agreements are prohibited in this way, then it will abrogate the RSO, that goes into sort of specific examples that discuss parking and sort of the issues that they sort of saw on the ground, and it spells out almost the situation exactly of what they were trying to avoid with with this ordinance. And so I'm inclined to accept staff's recommendation on this. I do think the hearing officer interpreted incorrectly, and if it's not currently included in the resolution, I would ask that it be included, that the amount be refunded based on the tenant's preference. And if anyone else wants to go next. Vice Chair Moore.
I'm in agreement. I mean, when you look at the lease on page 295, you can clearly see that it's an additional fee. It's not part of the base rent. I also thought it was interesting on page 284 that the storage area is listed as a housing service. So to me, that would mean that it would be included in the rent. So I will also go with staff's recommendation on this.
Thank you. Commissioner Kirby's.
This is difficult for me because the law is pretty clear. I think that this is a horrible situation as an example of why this law exists. In fact, it makes me want to change this law, which I've never wanted to do before, and I've been on this commission for over 10 years. It really upsets me that I think the law is clear. You have a right, the tenant has a right to this refund. I appreciate the fact that you mentioned that it's nothing between the two of you, and I think that hopefully the landlord hears that this is not the tenant filing anything against you, and I do agree that in situations like this, it is the current landlord's responsibility to make good on it because you have the capability and the tools to go after the prior landlord if there's a cause there, but I have to say that this again. There was no harm done in this situation. Both the tenant and the landlord agreed on the amount. There was no trickery, no attempt. And from what I understand, the attempt to raise the rent was only on the 1995, or even if it was on the entire amount, they were corrected so that the tenant was not harmed in any way. If the tenant would have come to us and said, I'm tired of paying this $200, but they keep making me, they demand this $200 from me, then I would feel differently. That this would fall into the why the law is created. But I look at this as a protection for the tenant in one way, because if they were to come to us in a regular hearing and say, I don't know the specifics of the size of the storage here, but we usually don't give $200. You wouldn't get a $200 reduction in rent if the landlord took the storage away, most likely, except in your case where you have a lease that says I specifically paid $200 for that. I should get $200 back if I were not to use it or if they were to take it from me. Most people don't have that protection. Most people in the city would get, I don't have the chart in front of me, but much less than $200 rent reduction for a loss of a storage space in the garage. I do see this as a separate thing from your standard housing. I don't equate it to refrigeration or air conditioning or anything that involves where you live. But again, the law is the law, so I'll agree with to overturn the hearing examiner, but I don't want to. And again, it makes me really want to rethink the law and the way it's worded, because I see this as having to refund money for something that you were utilizing, or that the tenant was utilizing. I don't mean to make this personal. That the tenant was utilizing this entire period under that agreement. I don't see the harm in it, and so I will go with the law because that's what we're required to do. But I just dislike it.
Commissioner Rory?
Yeah, I think I would reluctantly adopt the staff resolution. I have been kind of persuaded that there's a good policy reason for the rule. I just think that as applied to the facts here, it's a tough pill for me to swallow, but following the law and the evidence, I would adopt. I guess the resolution, one clarification I had is, I'm not sure how the rest of the commissioner feels about insisting that it be a refund versus a credit versus just letting that process play out according to how the city would normally resolve it. I feel really reluctant to tell the hearing examiner on remand, you have to rule for a refund if there's other alternatives, but I would ultimately adopt the resolution.
And Commissioner Bass?
Yeah, I have a question for staff before. On the issue of refund versus deduction of rent, can you explain the policy on that? Because my understanding is that's kind of resolved with policy.
Yeah, so currently the policy is that at the decision, the landlord is given a certain date to pay the lump sum of the overcharge. And if it's not paid within a certain date, then the tenant could start deducting that from their rent until it's completely paid off.
So the deduction's kind of a backup.
Correct.
I'm not sure if that satisfies the chair's questions, but I wanted to kind of get what the policy was on that. So I appreciate what my colleagues have said. I think that this is a good policy. And I think that the unanimous city council that adopted this a few years ago was right adopting this policy. And I think that in the city of West Hollywood that we have a situation here where both the landlord, I'm going to assume, was naive about policies as well as the tenant. And in the city of West Hollywood, we tend to err on the side of the tenant when they're both naive about what the policies are, the tenant gets the benefit. And I think that's what's happened here. No one knew, I think, that signed this, that it was not allowed under the code, and so the city has decided that we benefit the tenants on that. But I'm also, I'm looking at the fact that this compliance decision determined that it had not been re-registered, and so that the attempted increase in 2023 was not factual. And although that issue is not before us today, they then re-registered, and when they re-registered, they listed the rent at $19.95. So even after they went to a hearing and heard that this $200 was potentially problematic, although they won on that case, they still decided that the rent was $19.95. So at that point in time, the landlord, and I recognize it's not the one before us tonight, doubled down and said the rent was $19.95. So that makes me less sympathetic to it being part of the rent. So I think my comments are obvious that I will support staff's recommendation.
Thank you, and thank you for providing that clarification. So we don't even need to amend the resolution. It's sort of baked into the pie. Fantastic. Is there a motion regarding the resolution on this item, resolution 24647?
Chair, can I just clarify one thing? I
Yep.
just want to say for the record, I also supported, voted for that recommendation went to the council. I support the recommendation to the council. I support the policy. It's just, this is the problem I have with it.
Thank you. Is there a motion?
I can make a motion. Thank you, Chair. I'll make a motion to adopt resolution RSC 24-647, a resolution of the Rent Stabilization Commission of the City of West Hollywood reversing the hearing examiner's decision as to application number D-4817. Thank you.
I'll second that motion. We have a motion and a second. Can we have roll call, please?
Yes, Commissioner Bass?
Aye.
Commissioner Kirkes?
Aye.
Commissioner Rory?
Aye.
Commissioner Topshin? Vice Chair
Aye.
Moore?
Aye.
And Chair Wright.
Aye. We have a unanimous decision on this. So the motion passes. We went with what staff recommended, which was to reverse the hearing officer's decision. If you have any additional questions, and I would say specifically to you, since you sort of mentioned that there had been a potentially, unlawful increase, that you speak with our rent stabilization department about that issue and see if that, if that can be resolved outside of the normal process. And with that, we'll move on to item number 9, which is new business, the WeHo Pride Parade 2024 parade participation.
Gloria, we're ready for the new business item.
I'm so sorry. Yes, the new business item is the float for the WeHo Pride. And so traditionally it was the chair and vice chair of the advisory boards and commissions that were invited to participate on the float. They want to make this a little bit different and make sure that everybody that is interested in participating in the float do so. And what City Clerk's office is asking is that you tell us tonight if you are interested in participating, and then what's going to end up happening is they'll put your name in a raffle, and the 2 people that they select are the ones that are going to be on the float. So we just need to hear from you if you're interested, so we could put your names on there, and then you would be notified if you were selected to be on the float. Now, that doesn't mean that you can't participate at all, because I think there's going to be a trolley for those ones that weren't chosen. There's going to be a trolley that you can also ride behind the floats, and they'll also need 2 backups in case one of the 2 that were selected aren't able to make it that day. Then we have backups that will take their place.
Awesome. Can we just go down the line and let you know?
What's that?
Can we just go down the line and let you know?
Absolutely.
Okay, wonderful. Would you want to start?
In the years before, I was lucky to be on the float. There were no restrictions. It was a lot of fun. But this weekend, I think I'm going to be out of town. I cannot really confirm at this point, so can I email you later?
We have to know tonight
because
we have to notify the clerk by tomorrow.
I missed that part, sorry.
No worries.
Yeah, unfortunately, I think I'm going to be out of town that weekend, so.
Okay.
I agree with Commissioner Topshin. It was very fun in the past, but I will be out of town.
No.
I'll be out of town.
I don't have nearly enough time to get a backup outfit and a primary outfit, so I'll be fine. I'll let somebody else have my spot.
Yeah, I will defer. I give my spot to someone else. Thank
Okay.
you.
But you can catch me in the parade. I'll be driving with Stonewall in a red Bronco, so look for me there.
Okay.
Can I suggest they not do this process anymore? I mean, this is a weird raffle backup thing. They've never had a problem in the past. I don't know why they're doing
Right,
this year.
because each commission and advisory board would send 2 people, and it was normally the chair and vice chair. And I don't know if somebody may have complained, I don't know, but now what they're saying is instead of always selecting a chair and vice chair, if anybody on the board or commission wants to participate, then please come forward, give us your name, and then we'll select from the Rent Stabilization Commission, there's 2 representatives. And if nobody can go, then we won't have a representative on the float for this
My
commission.
recollection is that they used to, and I don't know how many years used to be, but it used to be they would do call out all the commission advisory boards. Anyone who wanted to show up could show up. It wasn't even an RSVP even, but whatever.
Oh yeah, they did it like that last year. I remember that. Yeah.
My recollection is the same as yours from back in public facilities days, yeah.
Okay, so no commissioners are interested? Okay.
All right. Item number 10. Are there any additional items from staff?
No additional from staff, thank you.
Is there any public comment that's come in?
No public comment tonight.
I can always wish. Item number 12. Items from commissioners.
I'm sorry.
Go ahead.
I just wanted to thank you, Diane. You did double duty tonight, and I noticed it and appreciated it, so thank you.
Yeah, thank you. Chair, very quickly, just want to announce that, I don't know if the camera can capture this, the City of West Hollywood and the Russian Speaking Advisory Board, they invite everyone to participate in the 23rd Annual Festival WehoMishka that will take place in Plummer Park of the City of West Hollywood at 7377 Santa Monica Boulevard on Sunday, May 19th of this year from 11 a.m. to 7 p.m. And this is a great opportunity for potential vendors and performers to introduce their businesses and talents to thousands of people as part of West Hollywood Russian-speaking Community Cultural Heritage Month and during the festival on Sunday, May 19th. This festival, WehoMishka Festival, has become a tradition in the life of the City of West Hollywood and its Russian-speaking community of the greater Los Angeles area as well. The cultural and creative identity of the Russian-speaking community is embodied in its visual arts, history, and language. So everybody is invited. not just two people from the commission, but all the commissioners and the audience and everyone who can hear us. You know, I know some of the commissioners joined before. It's a really fun event. It's free of charge, no parking fee, no cover. Just come in and enjoy. Bring your kids, friends, families, and just enjoy the festivities. There will be a lot of food, music, raffles, and you name it, and a wonderful entertainment programming. Thank you.
Wonderful, thank you. Any additional items from commissioners?
Yeah, I just wanted to, another event that's happening every year in May. This year it's May 5th, the 79th anniversary of Victory in Europe Day. If you haven't been to the celebration, it's over at Plummer Park on May 5th at noon. It's a great celebration, music, there at the monument. And then also, I wanted to just let you know for the schedule, I will not be here on May 23rd or July 11th.
Thank you. I just want to wish everyone that is a happy Passover if you are celebrating. And with that, the next meeting of the Rent Stabilization Commission will be held on Thursday, May 9th at 7 p.m. Same place, same time. Have a great night. Thank you.